Speaker for today is Dr. Divakar, it's a big welcome to all of y'all, and I hope the session will be of use to all the ophthalmologists present and who are watching from anywhere. Dr. Divakar, of course, needs no introduction. He is the veteran on the panel here as it is, and one of those evergreen, enthusiastic professors, and now he's presently the managing director and the eye specialist at the Divakar Specialty Hospital. He's always been a part of all the societies in Karnataka, being its ex-president and secretary. He's presently the president of the BOS as well, and is one of those absolutely enthusiastic people leading us in many of these panels. Dr. Divakar, sir.
Welcome to this important session on legal literacy for ophthalmologists, which is coined. Name is coined by Iran Kumar. It's an important session which is to all the ophthalmologists. So I welcome all my faculty to this session, and we'll start the session with the first presentation. Jyoti, please start with the first. Good evening, everybody. I thank Karnataka Ophthalmic Society for inviting me for this session on legal literacy for ophthalmologists. My lecture today is the introduction to medical legal aspects in current ophthalmic practice. The attitude today is the doctor is only made for the services to mankind and to do charity. So amount charged as a professional fees is always more. Even on the slightest acquaintance, doctor is not expected to charge. Otherwise, one is labeled as money-minded and arrogant. All patients should be cured, otherwise a doctor is considered as negligence. Over 75% of doctors across the country are reported to have faced at least some form of violence. Escorts patients committed 68.33% of the violence. Doctors have been demanding a central law with stringent provisions for violators for effective implementation. Any Tom, Dick, and Harry can threaten, abuse, misbehave, or damage the property of hospital or a clinic with impunity, without any fear of law, as patient is always the aggrieved party. We work under maximum mental tension as we are accountable, emotional attachment with our patients, work for long and even odd hours, working even when we are not well. The threat of violence and litigation looms around us all the time, and even harassment by government agencies is a routine. The purpose of this session is not to know about the medical legal cases are increasing day by day. Attack on doctors and hospitals is going up. Litigations are more and more. Harassment from the agencies is on the rise. Newer laws are being enacted by the government. The causes of strained relationships, it may be patient-oriented, doctor-related, media-related, or attorney-related. The patient-related or unrealistic expectations of the patients for the treatment they have taken, increased awareness of the rights in general, and doctor-related or breakdown of doctor-patient relationships, less frequent visits, unwanted complex invasive procedures, medical media-related undue publicity of negligent suits and size of the awards, attorney-related or lack of experience on the part of legal fraternity, monetary considerations, etc. On expected lines, the focus of doctor-patient relation has undergone tremendous change. In every interaction between the two, the doctor suspects a potential litigant in a patient. Patient firmly believes or thinks that second or even a third opinion from a different doctor is something which he or she cannot avoid. Medical litigation that was absolutely unheard of in Indian context till 70s and 80s has slowly gained momentum during the 90s. There are various laws concerning the medical profession. The Karnataka Private Medical Establishment Act 2007, Preconception and Prenatal Diagnostic Techniques Act, which may not be applicable to ophthalmologists, Biomedical Waste Management Rules, Consumer Protection Act, Indian Penal Code, Indian Medical Council Act, Atrocities on Doctors and Medical Establishments Act. The suits by the patients can be filed either in the Consumer Code, Civil Code, or the Criminal Code. There are some general guidelines to avoid litigation. We should be kind to our patients. We should keep a good record essential to our defense. Inform patients of all the possibilities. Do not be afraid of second opinions. Be careful about what you say about others. Careless words may entrap another doctor in a needless malpractice suit. Train, monitor, and control your employees. Written protocols to be followed in all the phases of work. Your staff's negligence will usually be viewed as your own. In conclusions, we can say that medical legal suits can be minimized by following good standard of care, maintaining good doctor-patient relationships, written informed consent from all the patients, and documentation and maintenance of all the records. So in this medical legal session, today our expert faculty will discuss all these points in detail. Thank you for your kind attention. Thank you.
Thank you, Dr. Divakar. Is there a possibility by which we can just increase the sound, please? Because I think the audio is not loud enough. If on your systems, you can just increase that's to the audiovisual team. If you can just increase the sound, it would be much better.
Doctor, it's a full sound. Full sound is there.
Okay, thank you. Our next speaker for today is possibly the most fascinating person in teaching and knowledge on law, especially medical legal law. One of the most respected people in both the medical and as well as the law institutes across the country. Dr. O.M. Nandimat is the registrar of the National Law School in Bangalore. He's also one of the senior most professors and has an absolute passion towards law, medical law, and towards teaching. And very many of us doctors who've had imbibed and learned a lot of medical law are all his students, a fantastic teacher. He's also written many articles and review articles for the press, also comes up on TV very regularly. He's also an important component in formulating many of the laws and rules, and he's a consultant even to the government of India. Dr. Nandimat, talk next.
Hi, ladies and gentlemen. In this particular recording, we will together try to discuss and learn about telemedicine law in India. As you might be aware, it is just recently that telemedicine guidelines have been added to your ethical regulation. By that, I always say a new era as far as medical practice has just begun. So, we will try to understand what this telemedicine is all about and what kind of legal framework today we have in India, and also we would discuss why these are called as guidelines and not regulations. If you really look at the slide that has been showed, the first and the foremost point that needs to be reiterated here is the recent guidelines have been appended as Appendix 5 to the Indian Medical Council Professional Conduct, Etiquette and Ethics Regulation 2002. In simple and popularly, these regulations are referred to as Ethical Regulations of 2002. So, by adding a fifth appendix, these guidelines have been included. As I said, many doctor friends of mine do ask me this question, why they are called as guidelines. And they also try to really ponder over, because they are guidelines, whether they are perfectly binding. Well, without getting into the jurisprudential nuances, I always say they are guidelines because they wanted some sort of regulations which are not perfect in themselves but would guide the doctor. So, they are at nascent stage. So to say, you can call it as zero base that has been laid down, and they would evolve. As and when they evolve, they would be further taken to next versions of perfection. But whether they are mere guidelines, well, I would say they are binding to start with. They are binding. At the same time, they give you some kind of flexibility and greater amount of discretion, which conventional regulations or law would not give. But with that difference, if you try to understand what these regulations state, you would probably achieve the required outcome or desired output of this particular initiative. I must also tell you, with these guidelines, India has become one among the select few countries in the world which has got some kind of a regulatory framework vis-a-vis telemedicine. And I also say these guidelines have eradicated the speculation, because there was one school of thought, or you can say a group of doctors, who very vociferously contended, consistently took a stance saying that our law is anti-telemedicine for some good reasons, and getting into those reasons is not necessary here. They always took a stance saying that if you consult a patient, or if the patient is advised through telemedicine, this is what law looks as, not encouraging one. Law says it is not to be done. But this speculation has been put an end to with this inclusion of Appendix 5, which I have already referred. So, the first question that requires to be raised is, what is telemedicine? Well, let me tell you, the simplest, most explanation or answer to this question would be, when you use technology of any kind whatsoever in providing healthcare services to the people. It's a broad term, therefore, including healthcare, health education, so on and so forth. But provisioning of healthcare services by embracing ICTs is called telemedicine, can be taken as the functional definition for our purpose as far as this module is concerned. And it is believed ICTs are viewed to provide great solutions in healthcare delivery like other spheres of human activity. So, without any ado, I wanted to really scope. In this module, we would be focusing deeply upon the telemedicine practice guidelines, or so to say practice guidelines, which have been appended to your ethical regulations recently. But it can hastily be added, although we have defined telemedicine functionally for our purpose, it may not be completely out of place to refer you to the telemedicine guidelines defining telemedicine. Instead of they trying to or attempting to define it in their own unique way, or rather reinventing the wheel, what they have done is they have adopted the definition framed by World Health Organization itself. And it says the delivery of healthcare services where distance is a critical factor by all healthcare professionals using information and communication technologies for the exchange of valid information for diagnosis, treatment and prevention of disease and injuries, research and evaluation, and for the continuing education of healthcare providers, all in the interest of advancing the health of individuals and their communities, is called as telemedicine. Now, getting back to the brass tacks, that is to understand the telemedicine guidelines as they exist today in India. This is a lengthy document, and going through this document would take some amount of time and effort as well. And especially those who are pure doctors, having some kind of, let me use that word with lot of care, those who are not well acquainted with law would find it difficult to digest. That is why instead of doing all that acrobatics, the entire approach of these practice guidelines are based on 9 fundamental principles. And if we understand those 9 fundamental principles, we would have actually mastered these telemedicine guidelines. And the first principle is already displayed on your screen, ladies and gentlemen. It says there is no difference in standard of care between telemedicine and in-person care. So when you think of law, it is almost like logic. why you think of law with regard to healthcare service provisioning. If something goes wrong, you start thinking about law, you start thinking about dispute, and you also start thinking about dispute resolution, isn't it? If everything goes well, the patient is happy, the doctor is happy, nobody thinks about law. I don't think I am speaking something very difficult to grasp. So it says you think of law in case there is a challenge or a problem. So when there is a problem, whatever law says is, if you had treated the patient in person, how I look at your approach, the same way I would be looking at the approach if you have adopted telemedicine. That is why I have made it very clear. Telemedicine is only an interface or medium used in delivering medical care to the patient. So, patient safety continues to be the central part of healthcare. Therefore, there is no difference between the channel of telemedicine and in-person care provisioning. Law and logic applicable is same in both the cases. So, that is the first and the most fundamental principle which you need to keep in your mind. Like any sphere of life, you can't adopt technology very well from the first or from the word go. So, the principle number 2 as far as telemedicine guidelines or practice guidelines state, use of discretion before adopting telemedicine. It is for the doctor concerned who has been asked to treat a patient by adopting technology. It is his call to satisfy himself. It is his call to take whether he would be successful or reasonably successful in adopting technology. That is why doctor is well positioned to decide whether technology based consultation is sufficient or an in-person review is needed. And if the doctor feels essential to physically examine the patient, he shall do so without adopting the technology. And if use of technology is not working out, the doctor shall insist upon in-person examination. In sum and substance, the take-home point here, it is the call of the doctor. If he is comfortable, then he can adopt telemedicine. If he is not, then he should insist upon in-person consultation itself. But it may not be completely out of place. Some of my doctor friends have innovated a strategy. They say, at least I will try to see the patient for first consultation physically, and subsequent consultations can be followed by telemedicine. Continuing to principle 3, it is very simple, rather not so complicated. It says there is no anonymous consultation. Probably they have included this as a principle to combat the issue of quackery. There are a lot of quacks who are attempting to treat, who are pretending to, treat as well, right? So, to prevent that sort of a quackery, they have made it mandatory that there cannot be anonymous consultation, meaning both patient and registered medical practitioner need to know each other's identity well. And the doctor should begin consultation by informing about his name and qualifications. So, that way the patient would understand who is a doctor whom he is consulting, and the doctor would also be able to identify the patient by certain identifiers. Coming to the fourth principle, it says use the best possible technology. When you really look around, I am 100% sure you agree with me, there are multiple options of technology available to you. Like WhatsApp can be one possible medium of technology platform. Facebook can be another. Google Meet, so on and so forth. I don't want to take lot many names, but you have multiple options of technology available before you to choose from. Whether you need to choose X technology or Y technology, which one is the best technology? Well, the guidelines are technology agnostic. They don't try to favor one technology over another. But it says, let, depending upon the circumstances and the requirements of the treatment, the doctor take a call at the end of the day as to which technology he would rely upon. And to quote these guidelines, practice guidelines, they say, considering the situation, using his or her best judgment, the registered medical practitioner may decide the best technology to use to diagnose and treat. Principle 5 speaks about understanding the limitations of telemedicine. I don't know, many of my doctor friends actually educate me here, and I sort of resonate their sentiment. Many clinical signs which are essential for the doctor to diagnose as well as treat are difficult to demonstrate via video conferencing and without a doctor's assistance on the other side. The feel of an organ or palpitation cannot be obtained by telemedicine as effectively as in-person consultation. And this limitation you can overcome either by insisting upon in-person consultation, that is one, that is the best. If for some reason it is not possible, at least have a telemedicine consultation where you are, given some information by another physician, serving at the other end. So it is two physicians consulting and one physician has the proximity of the patient. That is why if physical examination is critical, then registered medical practitioner may insist for in-person consultation or recommend video consultation or examination by another registered medical practitioner or health worker who can better able to make this doctor who is by telemedicine treating understand the actual reality or actual situation of the patient. Continuing further, principle 6 is about prescription of medicine. Very simply, I understand the doctor's job is can be divided into two parts. The first part is you diagnose the ailment and then you go to the next stage of treating that particular ailment. And while treating the ailment, an integral part of that activity is prescription of medicine. And principle 6 concentrates on prescription of medicine. To quote the telemedicine guidelines, it says prescribing medicines without an appropriate diagnosis or provisional diagnosis will amount to professional misconduct. That is why the registered medical practitioner may wish to prescribe medicine via telemedicine only when he or she is satisfied that there is an adequate and relevant information about the patient's medical condition he has obtained. And prescribed medicines are in the best interest of the patient if they are advised or administered. And to make the job less complicated, what these practice guidelines do, they divide the drugs into as many as 4 lists, or they classify the drugs into 4 lists. Here is the drug classification. I said there are 4 lists. The first one is list O. It says the common medicines which are sold over the counter and are safe to be prescribed through any mode of telemedicine. You can very easily go for prescription. And then comes list A. These medicines can be prescribed during the first consultation through video mode or being refill prescription in case of follow-up consultations. And then we have list B, where doctor can prescribe to the patient who is undergoing follow-up consultation in addition to those which have been prescribed during in-person consultation for the same medical condition. And then comes the last list, that is prohibited list. And in the prohibited list, we have those drugs which have high potential of abuse and could harm the patient or the society at large if used improperly. And you need to be abstaining from prescribing these prohibited, what you call as the drugs. So this is how the drug classification goes, and you need to have clear, sort of an idea in your mind before you prescribe any medicine through telemedicine. It's a world where privacy and confidentiality is being tremendously valued. Therefore, these practice guidelines in their seventh principle, concentrate on ethics, data privacy and confidentiality. Probably it is suffice to say, as there is propensity of data compromise in the digital world today, the doctor should ensure that reasonable degree of care is required to be undertaken while practicing telemedicine. A very interesting thing which I would like to highlight, ladies and gentlemen, is that what these telemedicine practice guidelines state is the doctor, while practicing telemedicine, should ensure reasonable degree of care. Means he should try to take advantage of the technology which he feels is reasonably safe to be used. Right, but at the same time, there is one more provision in the practice guidelines which try to free the doctor of this apprehension or anxiety. The anxiety or apprehension is whether while practicing telemedicine he would end up breaching the privacy, or whatever the information he has gathered, if that information has been accidentally or intentionally been divulged by some third party, one who runs the app, one who has designed the app, etc., whether he would be held liable. Well, the guidelines very clearly say the registered medical practitioner is absolved from liability if confidentiality is breached by a technology breach or by any other person than the doctor. Let's say you have adopted WhatsApp for collecting lot of information and providing some kind of service. I'm just taking a very simple random example. And somebody hacks into the server of WhatsApp and there is a data breach. Whether the doctor can be held liable, telemedicine guidelines very clearly say no, you cannot hold doctors liable. Doctors can be held liable as far as breach of privacy and confidentiality only when it is demonstrated that he did not ensure reasonable degree of care while adopting the technology and going for telemedicine practice. Principle 8 talks about fee consideration for telemedicine services. It is in one way taken as corollary to the first fundamental principle. The first fundamental principle, if you may able to recollect, says there is no fundamental difference between when you see the patient in person and when you adopt telemedicine to treat him. So it's the same yardstick that has been adopted. And as a corollary or extension of that, with regard to fees, the present practice guidelines say doctor or registered medical practitioner may charge an appropriate fee for the telemedicine services provided. So he is entitled to collect fees for providing telemedicine. It has been made very amply clear. And for the fees charged, doctor should provide fee receipt. So it is ideal and it is recommended as well. Coming to the last principle of practicing telemedicine guidelines. They say explicit patient consent. We have a separate video talking exclusively about the importance of consent. How when you obtain consent for treating the patient, you are respecting the autonomy of the patient, so on and so forth. So, with regard to consent, it says consent before providing telemedicine care is imperative. It is absolutely essential that you have to take consent from the patient. And the consent here might be recorded in any form for subsequent verification or retrieval. Let me explain it by taking you through some simple instances. Suppose you are practicing telemedicine and your patient logs in and he says, "Sir, I wanted to have some kind of, let's say, consultation for the problem." At that time, merely he logging into the system or logging in and establishing a link of communication with the doctor can be taken as consent. Whether it is an express consent or implied consent, that argument or that discussion is not important here. But you can presume there is a consent. And when you go on with the consultation, if you wanted to collect some intimate intimate information about the patient, at that time you may seek one more fresh, what you call as a consent. That is going to revive the consent which he has given earlier. But otherwise also, the doctors can develop their own, unique way of filling up the form. Just imagine, before I start my consultation, there is a form wherein I have to fill some information and there is a verification clause that I am consenting to undergo the treatment via telemedicine, and for that I have to explicitly click and then say I accept that. Can also be taken as that. But the most important factor which you have to bear in your mind is when you are practicing telemedicine, consent becomes absolutely essential, and you have to design methodology of recording the consent and retrieving it in case of requirement. But before I go to any further, I would like to say these all are the principles on the basis of which a registered medical practitioner or a doctor is been facilitated to adopt technology for treating the patients. And the telemedicine in the days to come is going to be the new normal, is going to take and redefine the way doctors are treating their patients. Well, these telemedicine guidelines also contemplate a bit amount of certification and training before doctors can embark upon telemedicine practice. That we would probably talk little later in our intermediate courses, little more drilling deep into these practice guidelines. So, ladies and gentlemen, in this video spanning little over 25 minutes, we have actually understood what is telemedicine and how the new regulations or guidelines, what we call as practice guidelines, have put an end to the speculation whether telemedicine is allowed or not. It is a bygone era where people used to speculate. Today, telemedicine is encouraged. That is the point which we understood. And we also have understood the 9 principles on the basis of which these telemedicine guidelines stand and encourage the doctor to adopt technology in practicing medicine. In the near days, we would be coming out with an intermediate course where we would be talking little more in detail as to what kind of specifications while choosing the technology, or if you have to choose a technology, how you can do that. What are the best possible technologies that are available in the market which you can use, and what kind of certification that is required and how you can procure those certifications and things like that. We would be divulging there. I do hope that these 26-27 minutes watching this video you have enjoyed and you have got little more enrichment as far as your knowledge is concerned. Thank you very much.
Thank you, Professor Nandi Matsar. It's an excellent presentation on telemedicine and its guidelines and principles which has to be followed. We'll discuss about the question and answers at the end of the session. Next presentation is by Dr. Prakash Marathe. He's a practicing ophthalmologist and medico-legal consultation person. He's a senior vice president of IMA Maharashtra. He's a past president of IMA Pune and Maharashtra Ophthalmological Society. And over to you, Sir Dr. Prakash Marathe. Please start the presentation. Jyoti.
Hello. Good evening, all of you. I think I am thankful to Karnataka Ophthalmological Society for giving me this opportunity. It is a wonderful conference organized by Karnataka Ophthalmological Society as usual. And I thank Dr. Divakar, Dr. Rajashekar, and Dr. Ellen Kumaran for giving me this opportunity to present in this medico-legal symposium. Now, the topic allotted to me, I think it's very important from medico-legal point of view. And it is how to prevent litigation in ophthalmic practice and the current scenario about it. I think most of us are doing our ophthalmology practice in perfect way, that is various procedures, then surgical procedures. But then added thing is we have to prevent litigations. We have to safeguard ourselves from medical legal point of view. So for that, I think when you are doing some procedure, you can verbally tell the patient that it is quite safe. There are certain complications, but then it is not enough. It is a written document that is a consent what you have to take from the patient and the relatives. So what is the time of consent? When it is to be taken? Suppose the patient is getting operated at the end of the procedure. Otherwise, you were thinking that the procedure is uneventful and you thought that some complication has occurred. And now you are asking the patient to give the consent. Sorry, wrong. It is not the correct time to take the consent. It has to be taken beforehand. While deciding about the procedure, that is the proper time. How it's to be taken? I think only verbal consent is not enough. You have to document it in a proper way so that it stands legally in the court of law or consumer forum. Why it is to be taken? Because that safeguards you in future for any medical litigation which can occur in future. Another thing is the patient gets convinced and patient is quite confident about you and the full faith about you and your hospital so that the procedure will be done in proper way. What you have to tell in that particular consent procedure is you have to tell necessity of that procedure, whether there are any alternatives, whether there are any operating procedures options, any IOL options, and what is the end result. Suppose you are aiming for 100%, still that point of time, you don't tell that 100% result will be achieved. You can tell little less. And about the cost, suppose there are various types of equipments used, various procedures used, various IOLs used, probably the cost will differ. And that comparative cost you must tell to your patients and their relatives, because then otherwise they are confused, they are suspicious about the financial aspect of that particular procedure, and it may be costly what the patient feels. So transparency has to be kept perfectly. If the procedure is transparent, probably the patient has more faith and confidence, and future problems are avoided by that. What I always tell to my patients and to all the delegates in many more conferences, what I deliver the talk about this particular topic is, you have to promise less and deliver more. Because if you are telling the patient about 100% surety and guarantee, and if it is not achieved, even if it is 98%, patient and relatives are unhappy. About the costing, I always tell, suppose there are clothes, shoes, some TV or some electronic equipment. If it is a branded one, it is costing more. If it is general, non-branded, the costing may be a little less. So you have to explain that way, that because the IOL is branded, it is of very good company, the cost is more. Because the equipments used in that procedure are costly, and hence the procedure is costing little more. Probably patients and relatives, they can understand well. Guarded prognosis, suppose there is comorbidity like glaucoma and cataract, diabetic retinopathy and cataract. So what is the visual outcome? Don't assure 100%. It may be little less because of comorbidity. In the procedures like enucleation and eviscerations, probably there is no vision achieved afterwards. Such type of patients, they go home and after a few months they come to you after discussion with their friends and relatives saying that, doctor, I cannot see. I think at the time of procedure, I explained properly that the person is not going to see. But after discussion, he comes with some hope that he may see. In that case, it is very, very serious problem. Suppose you have taken proper consent, probably you are able to say that in this particular procedure, the vision gain was not possible, and that was already explained to you. Nowadays, many more surgeons in India, even abroad, they try to tell to their patients that after this particular procedure, they can go home driving a car. But I think this is the fantasy. Even if many of your patients can go home driving a car after cataract surgery, it's fine. But few of them, if they can't, I think they will be unhappy. So better don't give such promises of driving home and with the car after the surgery. There are various types of IOLs available nowadays, like multifocals and high-end IOLs. Give those options. But when these IOLs are costly, probably they have got some side effects also, some queries, some suspicions, some acceptance issue from patient's point of view. Nowadays, even if the end result of the procedure is very good, the cosmetic appearance is also to be worried about, like some redness, some watering, some small eye, swollen eye, big eye. That particular issue troubles the patient. So even that issue is to be taken care of in spite of very good visual outcome. In this consent business, I think counseling is very important. The counseling, you can counsel the patient, and suppose relatives and friends are not available, probably afterwards the relatives may say that they were not told about the fate of that surgery. Sometimes you explain everything to the family and relatives and patient is not being explained. Probably patient may say afterwards, okay, it was not very well explained to me. So better explain everything in front of patient and couple of relatives or friends. Because in that case, I think you can say that it was told to you in a proper way in front of your family and relatives so that there is no double mind. Your counseling can be in question answer session. Don't feel that you are the doctor and you know everything, why the patient should ask you the question. I think they have got full right to ask any question. Nowadays, they are Google doctors. They read so much and they ask you many more questions. Better satisfy them before the procedure. If they are satisfied, probably they will be putting more hope and more faith and more confidence. And whatever bad something comes out, probably they are ready to accept. Nowadays, there are ready modules available. Make them available for the patients and relatives. Printed booklets also you can provide to them with the material like cataract, glaucoma, squint, posterior segment surgery, like that. On the websites of various hospitals, even solo practitioners, they have got their own websites, and corporate hospitals, they can put the matter about that particular surgery on their website so that patients and relatives can read that material properly. Even videos of that surgical procedure can be provided to patients and relatives. So after seeing that particular video, many more questions in their minds can be resolved properly. So you can record the consent and counseling in a proper way. Not only recording, nowadays even documentation is important from court point of view, legal point of view. Even CCTV option is available. While you are discussing with patient and relatives, you can do that recording in CCTV. All these things are very important for patients' satisfaction. The same way, medical legal point of view also, it safeguards you in future from further litigations, possible litigations. And for that, you have to take consent. So essentials of a valid consent. Consent should be person specific, procedure specific. It should be free and without undue influence, persuasion, misinterpretation, or mistake of fact or law. It is under Indian Penal Code. So full disclosure of facts by either side is required. Patient shouldn't hide his past history, his family history, his known complications. And from doctor and hospital side, also we must tell the possible complications of that procedure. So valid consent, the competent person must be there. In case of major, he can sign for his own And in minor, that particular case, the guardian can sign. The children in between the age group of 7 to 12, there is a gray area, but still guardians are requested to sign on that. Two witnesses, definitely you can request for the signature. In the consent, that particular form, it should be simple. Any language, this is very important. The language in which the patient and relatives understand. All India Ophthalmological Society has come out with a booklet of consents that is in the language of English. Here in Maharashtra, we had that project of printing that booklet in local language, that is Marathi language. I was fortunate to be coordinator for that particular project, and we have came out with the booklet of Marathi consent book. The same way, in your state, in your language, that is Kannada, you can provide that local language consent to the patient. It should be specific. It should be clear, ambiguity should not be there. And mention common complications. This is very important. You must tell complications as well as alternatives to the patients and relatives. In case of emergency, evisceration, enucleation, that is a removal of eye, you must take second opinion. And I think that second opinion can be by choice of the patient's ophthalmologist and not your choice, because in that case, there will not be any suspicion. Written consent or implied consent. Then informed consent, relevant information of illness and treatment has to be explained. Significant material risk has to be explained. And as I have already told you, alternative modalities are to be told to the patient and relatives. Unusual or special risks may not be explained if they are less than 5%. There are rare risks. Those can be less than 5%. In that case, these risks need not be told to patient. But major risks, major complications, major side effects must be told to patients and their relatives. The last point is very important. That is refusal of consent. Think of postponement. Don't force the patient and relatives if they are not ready for surgery. And operate only if urgent. In that case also, proper consent by relatives and other people is very important. Doctors should not feel shy of informing and taking written consent refusal, so that patient should not feel that it was not told to the patient and relatives properly. So boldly document the non-compliance of your advice. Suppose patient is not following any advice, denying something at the time of procedure, at the time of surgery, you must write that in bold letters. Take other patient's signature also as witness. Consent of a child after 7 years, and as I have told, that is a great area, that is 7 to 12 years, is a must. And you must take the guardian's signature along with. There is no law as such that consent is a must, but MCI in the past has given the guidance. Implied consent can be constructed by the history. So history of the patient and that particular disease is very important. However, judgments from Supreme Court and National Consumer Forum stress the need for consent. Here, I remember one of my surgeon colleague who treated his friend who had the cyst, and he took that patient in the operation theater without consent. And there was a table death, unfortunately. After the death, he tried to take the thumb impression of the patient, but the patient was educated, so that consent could not stand in the court of law, and he was in trouble. So whosoever may be the patient, maybe your relative, your friend, and near and dear one, don't unfollow the procedure. You must take the consent. Treat every patient as the serious patient who can create any litigation in future, and safeguard yourself. Like the topic allotted to me is like avoiding litigation. It is your approach to your patient and the relatives. Talk politely, explain in proper way, give all alternatives, transparency in your procedure, and at the end of the procedure, probably it is a mutual understanding. That is the better doctor-patient relationship. If you try to maintain, probably litigations will not be there. I think I have tried sufficiently for your medical practice, which can safeguard you from these medical legal litigations. Hope this talk will be helpful and beneficial for you in your future. Again, I thank Karnataka Ophthalmological Society for giving me this opportunity for this medical legal symposium. Thank you. Thank you so much.
Thank you, Dr. Prakash Mawar. It was an excellent presentation.
Thank you. Thank you, sir. Thank you so much.
All the important points of how to prevent litigation, especially the different forms of consent, everything. The question and answer sessions will come at the end of this session. Next,
Sure, sir. Sure, sir.
presentation by Dr. Kaushik Murli. He will be telling us about documentation and maintenance of medical records with increasing litigation in practice. So Dr. Kaushik Murli is a senior consultant in Shankara Eye Hospital. He is President, Medical Operations, Quality and Education, Shankara Eye Foundation. He is a National Chair of Learning CI Young Indians. And is a co-chair COVID Task Force CI Karnataka. Please start your lectures.
Murli, and I will be sharing some inputs in terms of documentation and maintaining records with increased litigation. I take this opportunity to acknowledge the office bearers of KOS, as well as the scientific committee chairman, the organizing committee, especially Dr. Ilan Kumaran and Dr. Divakar for inviting me to share thoughts on this topic of documentation and maintaining records in this era of increasing litigation. I acknowledge Samartha Srinivasa, founder JK Legal, and my colleagues Dr. Geeta and Dr. Kamala for inputs that they have shared as a part of that I've used as a part of this presentation. Now let's imagine a scenario. There's this patient who's about 57 years old. He's a diabetic since the last 13 years, seen at multiple hospitals, and he lands up in your clinic with reports of OCT, FFA, perimetry, visually evoked response, even a CT scan of his head. He complains of decreased vision that has been gradually progressing over the last 2 years. You examine him, you find out that the right eye, he's counting fingers at about 3 feet. In the left eye, he's counting finger at about 4 feet. And the fundus exam shows diabetic retinopathy changes. The FFA report that he's carrying shows significant macular edema, and you advise intravitreal triamcinolone, and the patient agrees to it. He pays for it. You give that injection. The patient comes back after a few days. You then do a laser for the right eye. Again, your case sheet, you document, just get a signature done, and call the patient back after 3 weeks. You want to repeat the IVTA. The patient refuses it. So at that point in time, you give him a subconjunctival triamcinolone and do a laser for the left eye. You call the patient back after 3 weeks, and then you do the second sitting of the laser and advise the patient to come back after a month. This is almost now 2 months since the first time the patient landed up at the hospital. And this time the patient is extremely aggressive. You record a vision of 6/60, and because of the rude manner in which the patient and his caregiver speak, you refer him to a higher center. After a few weeks, you suddenly get a registered letter, and you notice that the patient has filed a complaint against you in the Consumer Redressal Forum. You read what the lawyer has written, and you suddenly see that he is saying that, well, we knew that the patient was diabetic, but we did not control his sugar level before conducting the laser. And he also claims that we were in a hurry in treating both the eyes without waiting for the first eye to be cured. You're even more surprised because the patient claims in this notice that we did not explain the risk, neither did we take his consent. So you are completely lost, saying that why did he then come back 3 times, 4 times? But then imagine you are in the court. Who do you think will be believed? Probably the patient. Can you defend the charge of poor record keeping? You barely scribbled a few papers? Probably not. Would the outcome have been significantly different if the notes supported your position without question? Almost certainly yes. In this particular case, which I have pulled out of an actual case record, the consumer court ruled saying that no record has been produced by the opposite party or the hospital with regard to tests that the hospital may have carried out upon the complainant. Also, it went on to say that the hospital relied upon records of previous hospital and did not conduct any tests before conducting the procedures. And the lack of tests as well as the lack of records amounts to deficiency in service and adoption of unfair trade practices, which constitutes medical negligence, and a payout was thereafter such advice. Another scenario, you examine a 24-day baby who's a premature child, and then write in the notes, no ROP seen, discharge the child, and then ask the child to come back for follow-up specifically to the retina clinic where such children are closely monitored. Again, this is an actual case where a consumer court ruled that the doctor should have performed a retinal examination with a binocular indirect ophthalmoscope with dilation of pupil with scleral depression. And the court view was neither the doctors had done examination nor had they advised follow-up, and a 6.4 million payout was done. So it is not just adequate for us to draw diagrams, but also to indicate somewhere that it was done with indirect ophthalmoscopy with a fundus evaluation. We will claim that India has almost about 9 million blind. There are barely 11 ophthalmologists per million population, maybe about 15,000 of us, and there is a whole lot of work. But you need to understand, saying that there were almost about 3,000 cases that were filed in the National Consumer Redressal Forum between 2000 to 2020. Of this, 30 were cases related to ophthalmology. Almost in 75% of them, medical negligence was proven. A majority due to cataract, the highest compensation being almost 1 crore, and the average compensation being almost 24 lakhs. A survey has shown that there is greater consumer awareness, there is great flexibility and ease with which cases can be filed, and the cost involved in providing care today results in high expectations from the patient in terms of outcome. And there is a general litigant mindset, so you cannot wish it away. Across the world, ophthalmic malpractice suits have resulted in large monetary awards, and the most frequent factors influencing the decision include altered records, poor documentation, informed consent problems, failure to see the patient properly, failure to obtain or follow advice of the consultant. You will suddenly notice none of these talk about the competency or the quality of surgical care that was provided. So this again reaffirms the need to have a well-documented record that not only reflects the patient's history, the corresponding care, thereby allowing a continuity of care, but will be a great defense for us whenever there is an allegation of malpractice, demonstrating that we adhere to the standard of care. Again, the consumer court in various judgment has shown, saying that although it may be a time-consuming and a costly process, ultimately patient records can help or tarnish a doctor in medical negligence cases. So first, let's be aware, there are not just the Consumer Protection Act, but number of other acts that are bearing on us, from the Indian Medical Council Act to the recent Clinical Establishment Act. And we would be pulled up not just in the consumer court, but required to produce these records in cases of medical negligence wherever we handle a patient who has been referred to us following an accident as an expert witness, insurance claims, certain criminal cases, as well as in labor courts where some of our colleagues may bring us in. So when we talk of documentation in the hospital, it is beyond medical records, but due to paucity of time, I'm going to limit myself just to medical records for this particular talk. And time and again, it has been reaffirmed that it is the duty of the doctor or the hospital to preserve, maintain the medical record for a certain specified period. Now let's do a deep dive. Again, whatever I've shared so far reaffirms that medical records are immense help in medico-legal cases, and records not maintained, incomplete, brief or cryptic are of no use to us. What are all the records that are required, or what are all the stages of the patient journey where we will document? We should document this, not just remember this. Whenever we take the consent at registration, record history, examine, look at lab reports, do pre-anesthetic checkup, counseling, where we talk to them about possible diagnosis and outcomes, our operative notes, complications, vital parameters. In case there is a cardiac arrest, a code blue called if you are resuscitating. Post-operatively, your discharge summary should have follow-up advice. We will give instructions to the patient, asking them to come back. Each one of these moments of care have to be documented in the patient record. Now, what all should we retain? We should keep informed consent, including refusal to treatment. Say you advise the patient to take care and they refuse, it has to be documented. Investigations, not just ophthalmic, but any lab test that you may have ordered. The operative record should have details of surgery, the date and time, any assistant, the condition at the completion of surgery. Discharge should clearly mention follow-up visits where the patient can access emergency care, and you need not always have to write it out, but you could use a generic paper that carries these post-operative instructions that are ticked off, and you hand it over to the patient. If you are referring a patient, again, that has to be kept. The reason for referral should be documented. Medical legal records, death registers have to be kept for safe custody pretty much lifelong. Wherever you're handing any record to the patient, it is wise to keep a copy side. The Indian Medical Council Act says that medical records pertaining to indoor patients should be kept for a period of 3 years. And remember, you cannot deny a patient a record, but within 72 hours of a request being filed, you need to hand it over to him. Medical certificates, wherever given, you should have a register where you document identification marks of the patient and ask them to sign or apply a thumb impression so that impersonation does not happen. Again, you would be held liable. And we should make an effort to computerize the records. You could even scan it and upload it somewhere so that there is a copy for safekeeping. Time again, it has reaffirmed that the medical record is a very basic legal document. A well-organized, well-written record is the best defense for us. A good record communicates vital information about the patient's history, health status. It acts as a basis of planning medical treatment, serves as a source of information about the quality of care. It records consent, refusal, referrals, etc. It's a source of information for insurance. Research, education are enabled, and it provides evidence whether we've been professional about it. So whenever you're maintaining a record, make sure that it is accurate, up to date, placed in order. So file it chronologically. It should be legible where possible. At least the diagnosis and prescription should be in capital. Certificates, as I already mentioned, should be in a prescribed pro forma, preferably in duplicate with one copy retained with you. And keep a separate register where you document this. Do not maintain incomplete records or alter records because this results in suspicion. Your OPD records specifically should have the name of the patient, the complete address. This becomes more important because today in 72 hours you can email the record and this should be sent to the address recorded so that data privacy of the patient is recorded. Again, to reiterate, the OPD record should have complaints history, positive and negative findings, examination and follow-ups. Prescription should have the dosage and where possible side effects should be documented too. Consent is very, very critical. When a patient walks into a hospital for exam, it is assumed that he is giving us an implied consent. But for every other process, you have to take a consent that is documented. This has to be voluntary and the permission is given for a particular act. What do I mean by that? If you have to take up the patient for a second surgery or even a resurgery for a complication, you have to document yet another consent. The consent is only waived off if a patient is in coma, requires emergency treatment that could be life-saving, or in a medico-legal case where they're referred by a court of law or for examination by a court of law specifically. Your IP records, again, surgical complications are the most common cause of malpractice claims. It should not just document the surgical details, but again, the discharge summary should have a brief of whatever investigations you've done so that it shows that the procedure done is based on a diagnosis that again is supported by your investigations. Where possible, make sure that you have an electronic backup of these records. Follow-up is very, very critical. Quite often we ask the patient to follow up but barely document it. This can result in a lot of problem. If a patient comes back to us with complaints, make sure that you prioritize them. Encourage your staff to make sure that the senior most doctor available sees. This will often help in making the patient much calmer, his attenders much calmer, and can prevent any litigation that can happen, especially whenever there is an unhappy patient. Again, to reaffirm the importance of follow-up, the Supreme Court in one of the largest compensations awarded 1.8 crores to an 18-year-old girl who was not advised follow-up or referred to an ophthalmologist despite her being born as a premature infant. So this becomes very, very critical in terms of documenting referrals as well as follow-ups. It is never possible for us to be 100% accurate. Where you made a mistake, don't throw away the record, don't use a whitener or erase it. Strike through very neatly, write the correction, date and sign it so that the chronology is retained. Again, make sure that you don't destroy records, don't add any personal comments about how annoying the patient was or how you think that they're going to create a problem, because that is a recipe for legal disaster. Again, don't take personal grievances with your colleagues or with the hospital management, saying that there were no beds available, a particular drug was ordered and not available. Keep it for your committee meetings, not for your medical record, because that can be pulled up and it can again come back and bite you. Make sure that you write both positive and negative findings. Make sure your notes are legible. Make sure you reviewed the laboratory data. Document health maintenance and wellness, because it shows that you care about the patient. Document your diagnosis as a differential or a presumptive diagnosis. Don't be very absolute about it. Again, this can cause trouble to you later. And time and date entries are very, very critical. There is this very important judgment by the Consumer Forum, which kind of summarizes the need, where it says that doctors should write the correct records in the operation record and discharge summary, and this should be made available to the patient without hue and cry. Information given orally is a matter of debate as to who is telling the truth. It is the duty of the doctor to state and record all details of the treatment given, medicines that are prescribed, and follow-up advice. The patient has a right to get his medical record pertaining to him and cannot be denied the same when he paid the doctor for his treatment and hired his services. So once again, I thank the organizers for inviting me for this particular session and for sharing some insights on the need for documentation. I do hope that none of us are pulled up in a court of law, but if you are, make sure that your documentation protects you. Thank you so much.
Thank you, Dr. Kaushik Murali, for the excellent presentation on the importance of maintaining medical records. It's an excellent presentation with all the what has to be preserved, what has to be maintained, everything in detail. Our next speaker is Dr. Anant Deshpande. He's from, he'll be speaking us on rights of doctors in medical legal cases. He's a director and eye surgeon at the Guru Prasad Netra Private Limited in Aurangabad. He is the director of Indian Medical Legal Consulting Services Private Limited. At present, he is the chairman of the legal committee of the All India Ophthalmic Society. Over to you, sir. Anand Deshpande, sir.
Medical legal cases, know your rights. About me. Right in medical legal cases to medical professional as a citizen of India, the rights given to all citizens are also there to a medical professional, but specific to the medical profession, that too in medical legal cases are negligible, but time to time the Supreme Court has and High Courts of India has pronounced some guidelines which has given the rights. The rights are right to choose the patient. He is free to choose his patient, has given the right to deny the patient. But in emergency, he cannot deny the patient. Right to charge his fees. In Corona pandemic, there was a misunderstanding of capping of medical charges. But High Court of Maharashtra and Tamil Nadu and Supreme Court given the decisions against the state governments. The High Court passed the order on petitions filed by Hospital Association of the Nagpur and Dr. Pradeep Arora. Decision pronounced by High Court against the notifications issued by the state government of Maharashtra. The court held that the Epidemic Disease Act, the Disaster Management Act, and COVID regulations do not empower the state government to issue directions in relation to non-COVID patients being treated in private hospitals. Chief Justice Supreme Court, Justice Bobde said, there is unanimity that cost of the treatment cannot be same in all states. Thus, it's ambiguous to impose a ceiling on the cost of treatment. Right to not sued unnecessarily and right to defend. The Supreme Court in case of Suresh Gupta versus Government of NCT Delhi says it is held that for every mishap or death during medical treatment, the medical man cannot be proceeded against for punishment. The medical man is not an insurer. he does not warrant the successfulness of the treatment or cure of the patient. Right to not get arrested. IPC 45 of the 1960, Section 304A, causing death by doing any rash or negligent act. The table death is generally inquired under 304A. FIR is registered, but doctor is not arrested, though it is a cognizable and bailable offense. In the past, doctors used to be arrested in table death under Section 304. But now, with the decision in the case of the Jacob Matthews versus State of the Punjab, Supreme Court has given guidelines that the doctor should not be arrested under Section 304A unless opinion is taken from expert doctor or a committee of doctors expert in that field. Right to indemnify against the damages ordered by CPA or civil court in relation to the professional cases. Indemnity insurance policies. Indemnity insurance policies should be taken for doctors and hospitals with staff separately and should be renewed every year to meet the claims of CPA. Medical profession is a medical industry. This is said by the Supreme Court in the decision, and that led to the right to get protection from the consumer cases if treated in corporate or trust or other type of hospitals, which one is not his solo hospital. As per the Supreme Court verdict, the Supreme Court in the Savita Garg and versus the director, the National Heart Institute, said the patients, once they are admitted to such hospitals, it is the responsibility to satisfy that all possible care was taken and no negligence was involved in attending the patient. In fact, it is the hospital who engages the treating doctor. Therefore, it is their responsibility. Therefore, no individual doctor is liable and cannot be held jointly or severally liable. Even visiting doctors or consulting doctors in private hospitals cannot be held liable. The consumer, that is patient, does not avail services of such doctors individually by paying fees or consideration to the doctors directly. Right to select the mode of treatment when the other alternatives are available. As per the decisions of the Supreme Court, doctors has developed the right to selecting the mode of treatment for his patients when other alternatives are available, as Supreme Court in Jacob Matthews petition versus State of Punjab said that the apex court says that the medical practitioner cannot be held negligent merely because he chose to follow one procedure and not other, and the result was a failure. In the opinion of the Lord Denning, the expressed in his case that a medical practitioner was not to be held liable simply because things went wrong from mischance or misadventure through an error of judgment in choosing one reasonable course of treatment in presence of other. Thank you very much.
Thank you, sir. An excellent presentation on the rights of doctors, because most of us do not be knowing about rights. So it's quite a good explanation. Now, next presentation.
Thank you. Thank you.
Thank you. Next presentation by Dr. Reggie Thomas. He is a senior professor in St. John's Medical College Hospital and a visiting faculty, Lacoma Scholar at the University of Illinois, Chicago. He's got a PG teaching experience of about 28 to 30 years. He'll be telling us about effects on healthcare practice of the recent changes in the CPA. There are some Constitution has brought some changes in the recent CPA. What are the effects of that on the healthcare practice that he will tell us? Over to Reggie Thomas, please.
Opportunity to speak on Consumer Protection Act, what it means to us. We all consume goods. We all utilize services on a daily basis. and we expect some degree of satisfaction. However, we are definitely not satisfied every time, all the time, for various reasons. Maybe the quality of the product, maybe the content of the product, or the poor service that we get. Goods can be variable commodities like salt, it can be television, it can be a car, and services can be as simple as electricity, telephone, film shows, doctors, architects, etc. Who is the consumer in the eyes of the law? It can be either the purchaser or the end user. For example, I may take my child to a hospital and my child receives medical treatment, but I pay the bills. So I am the purchaser and my child is the end user. Both of us are considered consumers. John F. Kennedy first gave 4 basic rights to his people in 1962. Right to safety, right to be informed, right to choose, and right to be heard. The General Assembly of the United Nations passed some resolutions and guidelines in 1985. These guidelines were meant for member states to utilize, to develop on, and bring in their own rules, their own protection systems, and their own bills. India brought in such a bill known as the Consumer Protection Bill 1986. This act is applicable on all products and services unless specified by the central government. This act is applicable to all the areas, be it private, public, or corporate. So what happened before the Consumer Protection Act of 1986? People went to criminal courts, went to medical boards, and went to civil courts. Was it simple? Not at all. There are many difficulties even in a civil court. One, you have to pay an upfront court fee. You have to prove that the complainant has to prove that there was an absolute deficiency. It's a long and prolonged course. The rules and norms of the court has to be followed absolutely. You have to follow the CPC and the Evidence Act, and it's very technical, which also means that you have to employ a lawyer. And if you went to criminal courts or the medical boards, you never got any compensation. Therefore, the present system brought in consumer courts where these technicalities are removed and it's very simple. And they are pro-consumer or pro-patient. Are doctors under the CPA? Yes. The Act of 1986 brought doctors under this purview or under this ambit of the CPA. However, there was some degree of misunderstanding that certain high courts said they do not come, certain high courts said yes, they come, and therefore there was difficulty in interpretation and there was an imbalance between states and between high courts. However, in 1996, the VP Shanta versus IMA case was very decisive, and doctors were known or was declared to come under the purview of the CPA as long as they paid a consideration. Exempts free service at charitable hospitals and government hospitals. So a doctor or a hospital which is not charging at all, government hospital not charging, is exempted from this purview. However, this patient can still take you to a civil court, to medical bodies, and criminal courts. And the system of the consumer redressal has a 3-tier system. And this was basically dependent on the compensation being paid, and it restricted itself to the district level, the state level, and the national level. A complaint by a patient or a consumer had to be filed within 2 years of the grievance. The cases are expected to be decided in a short time or 90 days, which of course I've never seen nor heard. They had a process of appeal. Now, if either party was not happy with the final order, you could go to the higher court. And this you had to do within 30 days. And if you were not happy at any level with the consumer courts, you could go to the Supreme Court. On what values did you have to go to each of these forums? If you are claiming less than 20, you went to the district forum. If you're claiming between 20 and a crore, you went to the state. And if you're claiming more than a crore, you went to the national commission. If the complainant was found to be frivolous, or the complaint was found to be frivolous or vexatious, the complaint would be dismissed, and they can even be penalized for up to 10,000 rupees. What is the new Consumer Protection Act? The new Consumer Protection came into effect on July 20th, 2020. Here, the focus was more on the consumer welfare rather than just the dispute redressal. The Consumer Protection Act 2019 provides for greater protection of consumer interests, taking into consideration the current age of digitalization and technological advancement, which many of us are exposed to. It finally intended to make the consumer the true king of times. How did it affect us? Initially, it was speculated and thought that CPA did not apply to medical services, but this was not true. CPA applies to all medical services which was bought for a consideration, even if it was under concessional rates. Medical services rendered free or as charity is exempted, and the law applies to both government hospitals and private hospitals, just like it did in 1986. But then what is the key differences? One, the complainant or patient can file his complaint from wherever she lives, whereas in the previous, you had to do it at the point where you purchase or the production, or if it is in a hospital, related to a hospital, in the city where the hospital was. This can be really dangerous when it comes to teleconsults and video consultations. It allows for e-filing. So you go onto the net, you find the consumer code, and you can file in your complaint. And it is deemed that it is admitted if it is not rejected within 21 days. A consumer can therefore just get in on the particular date and conduct his whole case just on video conferencing. And therefore, a lawyer is not an absolute. However, there's a recent notice on the 15th of November which says that video conferencing is not allowed any longer. And now, how does the jurisdiction come? Is there a change in the value or the quantum that you can sue or you can be taken to a court? Yes, it has changed from what you're claiming to what it is the value of the product or the value of the service. Therefore, the district forum can take goods or services up to 1 crore, the state commission up to 10 crores, and if it's more than 10 crores, you go to the national commission. However, the complainant does not have to pay a single pie if the value of his complaint or the service he's utilized is less than 10 lakhs. There's also a concept of product liability, which is more into consumer products than actually medical products, where it is not just the product or the manufacturer of the product, it's also the seller and the platform which sells it, like Amazon, which can be taken to court and sued for a poor quality product because he didn't verify the quality of the product. Misleading advertisements and celebrities who endorse such products can be penalized, can be debarred. For example, if you have one of these Shah Rukh Khan, for example, telling you that you put a drop and your cataract disappears, it's a misleading advertisement, and he can be barred from doing such things. Two, there's also, and the additional point is that the present act allows for mediation or mediation centers to be involved, where two advocates and the concerned parties can sit, discuss, and settle it out of court. So there's hardly any time lost in mediation. Another important change is the Central Consumer Protection Authority, which has been introduced. This is an absolute authority on top of all this, and which guides these, puts in principles, and they have a lot of scope and powers to even investigate into what they think is going wrong. So it basically helps society as a whole, and they can take action suno moto. If what they come to know about something which is on WhatsApp or something which has come in the papers, they can consider taking it up themselves. Okay, they can recall products in the market. They can order a reimbursement to everybody who's, for example, a car comes up with a poor product which is repeated. They can ask, the whole system is brought, there's a change in that, and they can cancel licenses. Therefore, the intent of CPA aims at the overall welfare and rights of consumers, especially the ones who are unaware of these. So, what is the impact of the CPA 2019? One, we have to know as doctors that this is here to stay, and doctors are covered under it. There's no doubt about it. And we have to understand, it is not that a new draconian law is brought. No, it is just that what used to happen in civil courts is being brought to a different venue, okay, which is the consumer forum, which makes it easier, of course, for a patient to claim his rights. The purpose of this by the government is to provide quality and affordable care. However, how has it changed our life? We have gone into defensive medicine. Now, if somebody comes with, something a little suspicious, we say go to medical college. Or we say trauma and the eye, we go to a bigger center, which possibly we would have handled easier before. And therefore, it ups the cost, it increases the cost of drugs and the cost of medical devices. The bad component, really bad component is now most of the bills in most of the places are never exceeding 5 lakh. So if for some reason you've been tough or you acted smart or he didn't like your face, he can just ruin your happiness by filing in an e-complaint and saying, come on boss, I'll teach you a lesson. Okay. Now, also means that we need to be careful. And so we all take insurance, which makes our overheads higher. And that who pays? Finally, I'm not going to pay and do charity, so the patient pays. Of course, for advocates, it's party time because they've got a lot more bakras to jump upon and they know that we are weaklings. So, in other words, it threatens the nobleness and strains the doctor-patient relationship. What's the final verdict or the take-home message? The CPA is here to stay. It's like a leash around our neck, but the fact remains that it was always there and was there in developed countries even earlier. It is obviously designed to force medical profession and other professions and services to be more responsible, proactive, efficient, and up to date. Remember, forewarned is forearmed. And it is for us to know that, yes, there is a watchdog. It can get you into trouble. We better be careful and we better be prepared. And let's continue to work at the oath we have taken, the Hippocratic Oath. Thank you very much.
So thank you very much, Dr. Reggie Thomas, for the excellent presentation on the CPA and the recent amendments. I think there is no time for much question and answers.
I think we have 2 minutes, so I'm going to ask Dr.
Anand, you can summarize.
A question. And
my question to him is, summarize.
Yeah, I have just one question, and that's to Mr. Anand Deshpande, because I think he's most literate on law. The question is, now so many of us are taken to court. Do we ever go back and claim something as a defamation for the people who take us to court? Because most often we finally win the case in court. It's just that we've been hassled for so long. The media also finishes us off. And we have definitely lost face. We've gone through a lot of things and we've developed hypertension, etc. Is there a way of rebuttal or hitting back at the people who take us to court?
Yes, the doctors have no rights to ask for defamation in the court when the case is even against the patient, because that is the case. One has to win and one has to lose. So no one can say that that is a defamation. But if the papers, the media has made your defamation, then it can be done. But at present, the media are not doing anything unless and until the court decides the case, because there is some restrictions on them also.
One more question. Do you think every lawyer in the country is capable of handling our cases? See, many often people have cases now, especially since they can go to any district level court because the cutoff is 5 lakhs. So do you think that that is enough, what I'm asking is, any lawyer do you think can represent or take up a medical legal case, or do you think we need to identify who can represent us? Because very often most lawyers don't understand what we talk.
Yes, you are very, very right. The common lawyers who are conducting the common cases, they are not capable of conducting a medical legal case. So a medical legal expert who is having the knowledge of the law plus the medical knowledge is the person who can help the doctors. And if the case is defended by such a medical legal expert, then it is a definitely, and more often it is a win, and doctor will not lose it. So the doctors should find that the medical legal consultant should be consulted and should be taken the opinion, and all the things should be done by them only. So they will win, because what happens, whatever is brought in front of the judge, on that the decisions are given. And if the common lawyer is not able to show what are the medical facts and what has happened, he loses the case. So medical legal expert is very, very important in all these such cases.
Doctor, sorry to interrupt. There is a break for 5 minutes. We'll continue at 7:35. So there is some technical issues going on.
I think
I don't think we'll be continuing. I think we're going to close. Dr. Divakar?
I thank on behalf of KOS, I thank all the invited faculty and our KOS members for the excellent session on the medical legal today session. I thank you all once again. Any queries, sir, we'll get back to you and we
Thank
can
you.
answer online or
Thank you.
we'll keep in touch with you. Thank you very much.
Thank you.
Thank you
Thank you
all
so
for
much
the
for the opportunity.
Sir,